the Domestic Violence Act, Section 5, breach of protection order. Subsection 1. Where a protection order, whether interim or otherwise, is made and A. it is served personally on the respondent, and B. the respondent contravenes the order in any respect, the respondent commits an offense and is liable to conviction to a fine not exceeding $10,000 or to imprisonment for a term not exceeding 6 months, or to both such fine and imprisonment. 2. Subject to the provisions of this section, where a protection order is in force, a constable may arrest without warrant a person who he has reasonable cause to suspect of having committed a breach of the order. 3. A person shall be arrested pursuant to this section unless a constable believes that the arrest of that person is reasonably necessary for the protection of the prescribed person. Oh, let me read that again. 3. No person shall be arrested pursuant to this section unless a constable believes that the arrest of that person is reasonably necessary for the protection of the prescribed person. Oh, so if that person is arrested, they can sue the state. I mean, if it is found that the constable arrested them without having the reason that it's reasonably necessary for the person, the prescribed person's protection, then they can win that lawsuit for false arrest. So the constable can only arrest the person if the constable believes reasonably that such arrest or not arresting the person not arresting the accused might endanger the prescribed person. All right. 4. For the purposes of subsection 2 and 3, the constable shall take into account A. the seriousness of the act which constituted the alleged breach, B. the time that has elapsed since the alleged breach was committed, and C. the restraining effort or other persons, the restraining effect of other persons or circumstances on the respondent. 5. Where the arrest is made under this section, A. a person arrested shall be entitled to make a telephone call to one person of his choice, not being the applicant. B. the constable who makes the arrest shall ensure that the person arrested is informed at the time of the arrest of the right conferred by paragraph A. So the constable should tell the person that they can make a telephone call to one other person. And C. the person arrested shall be brought before the court within a period of 48 hours beginning at the time of the arrest. So 48 hours, within 2 days, they should be brought before the court. Duration and discharge of protection order. That's section 6, subsection 1. A party to the proceedings may apply to the court for a discharge of a protection order. 2. A copy of an application made under subsection 1 shall be served personally on each person who was a party to to the proceedings in which the original order was made. And subsection 3, subsection 2 again, a copy of an application made on the okay, maybe served personally. All right. Subsection 3, in determining whether to discharge a protection order, the court shall have regard to the matter referred to in section 4, subsection 2. Occupation orders. That's section 7, application for a grant of occupation order. Subsection 1. Application may be made to the court by or on behalf of a prescribed person for an occupation order granting the prescribed person named in the order the right to live in the household resident. 2. Subject to subsection 3, the court may, on an application under subsection 1, make an occupation order granting to the prescribed person for such periods or periods, and on such terms, the subject to such conditions as the court thinks fit, the right to occupy the household residence. Subsection 3. The court may make an order under subsection 2 only if the court is satisfied that such an order A is necessary for the protection of the prescribed person, B would be in the best interest of a child. Oh, right, A and B. Then we are at now section 8, ex parte application for occupation order. Subsection 1. An occupation order may be made on an ex parte application if the court is satisfied that A. The respondent has used violence against or caused physical or mental injury to a prescribed person, and B. The delay that would be caused by proceeding on summons could or might expose the prescribed person to physical injury. So remember, the ex parte application is the application done without the accused being present. Subsection 2. An occupation made on the ex parte application shall be an interim order and shall be served personally on the respondent. Interim order. So we're at page 11. It says be served personally on the respondent. Let's look back at the definition of the ex parte application. Ex parte application means an application made without notice to the respondent. Okay, so they made the order without telling the person. I guess at a later date they can serve it on the person. All right. 3. Subsection 3. Where the court grants an occupation order on an ex parte application, the court shall at the same time make an interim protection order unless it considers that there are special reasons why such an order shall not be made. Subsection 4. An occupation order which is made on an ex parte application while the prescribed person and the respondent are living together in the same household residence shall expire A. on the discharge of the order by the court, or B. on the discharge of an interim protection order made pursuant to subsection 3. So it seems as if the order may not have an expiry date, and then it is discharged by the court, or the interim order has an expiration date, so it automatically expires. Right. Subsection 5. Where an occupation order is made on an ex parte application, the respondent may apply for variation or discharge of that order. Section 9. Effect of occupation order. Where an occupation order is made, the prescribed person to whom it relates shall be entitled, to the exclusion of the respondent, personally to occupy the household resident to which that order relates. Okay. Where an occupation order is made, the prescribed person to whom it relates shall be entitled. So the person who is offended, or who is the victim, alleged victim, the occupation order tells them that they have the right to remain in the house to the exclusion of the respondent. So it says to the exclusion of the respondent, personally to occupy the household. So maybe the respondent may be forced out of it, or may still reside there. It seems like that's what it is saying. 10. Section 10. Variation of discharge of occupation order. The court may, if it thinks fit, on the application of either party, make an order A. extending or reducing any period specified by the court pursuant to subsection 2 of section 7, or B. varying or discharging any items or any terms and conditions imposed by the court pursuant to that subsection. Section 11. Procedure relating to occupation orders. Before making an occupation order other than an interim occupation order, the court shall direct that notice be given to the person having an interest in the property which would be affected by the order. And that's subsection 1. Subsection 2. The person referred to in subsection 1 shall, upon being notified pursuant to that subsection, be entitled to appear and be heard in the manner of the application for the occupation order as a party to that application. Shall, upon notice pursuant to that subsection, be entitled to appear and be heard. Okay. Section 12. Power of court to make ancillary order. Subsection 1. Subject to subsection 2, the court may, on or after making an occupation order, make an order granting to the applicant the use of all or any of the furniture, that's A, or B, the household appliances, C, the household effects. Subject to subsection 2. So the court may write that the person has a right to use the furniture and appliances in the household resident to which the occupation order relates for such period and subject to such terms and conditions as the court thinks fit. Subsection 2. An order made under subsection 1 shall continue in force for a period of 3 months from the date of the making thereof, unless the court otherwise directs, but shall expire before that period if the occupation order expires or is discharged. Part 3, general. We will read part 3 in a different video.